In the previous video, we briefly discussed procedural safeguards and you and your students' rights. To recap, the procedural safeguards outline the following: right to examine records, parent consent and participation in meetings, taking meeting minutes, independent education evaluations, prior written notice, resolving conflicts, placement during proceedings, educational surrogate parents, discipline and students with disabilities. Let's talk a little more about what each of these mean. Right to examine records. As a parent or student with a disability, you have the right to inspect and review all education records without unnecessary delay, including prior to a meeting about your or your child's IEP, before a due process hearing or resolution meeting. You can personally review your or your child's records or give consent for someone to review them for you. In cases where there is shared custody, the school will let either parent see the records unless an appropriate court order directing otherwise is given to the school. You have the right to know what kinds of records about your child are collected and where they are kept. After submitting a request to review records, the school must allow you to review them promptly, no longer than 45 days after you've requested to see them. As a general rule, always remember to put all requests in writing. Parent consent and participation in meetings. IDEA ensures parents have every opportunity to provide consent to the services their child receives as well as participate in meetings. Before any evaluations or services can begin, the school requires your informed written consent before they can proceed. However, even if you have consented to your child being evaluated, it doesn't mean you have given consent for the school to start providing services. Full written consent from you is required for services to begin as well. Parents must also be given the right to participate in their child's IEP meeting. The school must make sure you are receiving notice of meetings in enough time to make arrangements to attend. Additionally, meetings are to be scheduled at a mutually agreeable time for you and the other members of the IEP team. They must also make sure you know you are able to participate in meetings by phone or on conference calls, as well as providing an interpreter for those who are deaf or whose native language is not English. Lastly, to help prepare you for IEP meetings, you have the right to request any data relevant to your child's needs or disability and the presence of any staff member to attend prior to an IEP meeting. The IEP team must also obtain your input prior to the development of an IEP and must send you a draft if one is available prior to the IEP meeting. PIC always recommends requesting these items in writing. Taking meeting minutes. Parents, a parent's authorized representative, or any public agency conducting a meeting, review, or conference may take minutes of the meeting, review, or conference concerning a child with a disability's free and appropriate public education. Minutes may be taken by a disclosed recording device or by a stenographer. The cost of recording the minutes is the responsibility of the person or agency electing to take minutes. If minutes are taken by the school, parents must be offered a digital copy. Independent educational evaluations. If you disagree with the findings of an educational evaluation performed by the school, you have the right to request an independent educational evaluation, or IEE. This request should be made in writing. Qualified professionals who are not employed by the school or district should conduct the evaluation. If you obtain an independent educational evaluation or you share one with the school or district obtained at your own expense, the school or district may review and consider the evaluation in any decision concerning your child's eligibility for services. Prior written notice. The school must send written notice anytime they propose to evaluate your child or if they recommend or refuse to evaluate or change the identification or placement of your child. This notice must be sent to you at least 10 days in advance or 5 school days before disciplinary removals. The notice will describe the action the school proposes or refuses to take, an explanation why the actions were accepted or rejected, describe the evaluation procedures and assessments used to make the decision, as well as any other factors that led to the decision. As you can see, some pretty important information about the decisions being made regarding your child's education and the services they receive can be found in this document. You may receive this notice via U.S. mail or email and should expect to receive it after an IEP meeting has been held, a new or annual IEP has been written, whenever you and the district make an evaluation plan for your child, or whenever you make a request for changes on your child's identification, evaluation, educational placement, or IEP. Opportunity to resolve complaints and conflict resolution process. Procedural safeguards outline the steps parents can take when there is a disagreement regarding the special education and/or related services a student is receiving. When you and the school disagree, it is important to first try to resolve differences informally. However, if you continue to disagree with the school's recommendations, you or the school district can use one or more of the following options: facilitated IEP meeting, mediation, state complaint procedural, due process hearing. Details on how to initiate these processes can be found in your Procedural Safeguards booklet. Placement during proceedings. With the exception of school discipline and placement, or in the case of children transitioning from Part C to Part B services, unless you and the school district agree otherwise, your child will stay in their current educational placement for the duration of the due process hearing. This is called a stay put. Educational surrogate parents. An educational surrogate parent must be appointed when the parents of a child with a disability cannot be identified, found, or when the child is in the custody of the Department of Services for Children, Youth, and their families. Discipline and students with disabilities. Children with disabilities may be suspended, expelled, or placed in other alternative interim settings or other settings to the same extent these options would be used for children without disabilities, but are subject to specific rules and requirements outlined in your procedural safeguards. Procedural safeguards explain what happens when a student with a disability violates the code of conduct and steps that can be taken if a parent disagrees with the placement. This video provides a general overview of the rights and responsibilities covered in the procedural safeguards. You should request a copy to learn about the rights in detail. It's important to remember that procedural safeguards serve as a guide which outline parents, students with disabilities, schools, and the Department of Education's rights and responsibilities under IDEA. When you receive this booklet at the next IEP meeting, take some time to review it and jot down questions you may have. Perhaps you don't have a need for it at this moment, so store it with your students' educational records in the event you need to review it later. The more informed you are as a parent, the better prepared you are to advocate for your child. For more information about procedural safeguards, including additional publications and resources, visit the Resources tab at picofdell.org.